The only issue that we want to say in the context of the fact that the president appointed judges but did not appoint all the judges is this. The background is this, that we have the Judicial Service Commission that appoints and is charged with the responsibility of employment of judges, men and women, to work in the judiciary as arbiters of justice. When that happens, the executive role, and I talk of the presidency and in fact the president's mere role, is to appoint and gazette those that are brought to him. Now, the law does not say that when he is presented with a cluster of judges, being 42, being 100, being 30, he must appoint them on the same day. So it is wrong to say that the president has rejected the other names. It is not true, at least in law as matters stand now. What happens is that if the president chooses to gazette one person every day, if there are 100, he has that liberty. That's the discretion he has. He has, however, no discretion whatsoever in law to reject those names. So he has no place to reject. What he must do is that he needs to gazette those names, or in the alternative, and I say this out of logic, not of law, he returns with reasons to the Judicial Service Commission those appointments, so that that memorandum is considered afresh by the Judicial Service Commission. If that doesn't happen, then those that are charged with responsibility of coerciveness to make the president work, because the president, like any other state officer, can be coerced to work, is that the president in law can be bypassed by a pronouncement of the court to give him a delineated time, a timeline within which to make that appointment, in lieu of which those that ought to be appointed will be deemed to be appointed in law, and therefore they can take over office. Remember, the sovereign of the people under Article 1 surpasses the power of the executive, the judiciary, and the legislature. In fact, the appointment of those judges is to the people of Kenya and to serve the people of Kenya. The need cannot be gainsaid. There is need for that appointment. Service must be delivered to the people. So if the president does appoint them, he rejects those names through a memorandum back to the JSC to give reasons for a reconsideration available, so that the appointing authority, the employer, who is Judicial Service Commission, can rethink. Now, there's a problem. The problem is this. There are judges that are already serving on the bench that have not been appointed or gazetted by the president. Now, there is a system of complaints and removal of judges from the bench. If there's available any intelligence reports or reasons the president has that the judges may not be suitable to serve at the bench, then he has all the apparatus and law and systems upon which he can then excite them for purposes of setting up a tribunal for those judges to be removed. If the judges then are not removed and are not appointed, yet they have a right and a legitimate expectation to be appointed, that becomes unconstitutional, that becomes illegal. It's a matter that us as lawyers, we need to settle, but I do know that we are before the courts, and somehow, somewhat, we will find a settlement where we know best, and that is the courts.
As the president, former CJ Lukumba feels that the president has been violating several times, and he calls for his impeachment. What's your comment on that?
Now, there is the judgment that riled the president that stopped the BBI pronounced that the president has breached Article 6 of the Constitution. Now, the consequences of breach of Article 6 of the Constitution is that you can't hold a public office. And that's the position as we speak. The position as we speak, unless that decision is stayed or set aside, is that the president is unsuitable to continue holding a public office. He himself has gone back to the Court of Appeal in person through his lawyers to overturn that position. If that position is not overturned, then the position that is obtaining is that the president is not suitable to continue holding office as it is now. And therefore that is a dangerous path. But then the court opened up to the public and said the president can be liable. The president is liable in person to be taken to court either under civil or criminal proceeding in the context of breach of Article 6. That is very dangerous, because what we did in the Constitution is we insulated the president against any impeachment under civil or criminal proceeding. But the context was criminal proceedings, not breach of Article 6. So any breach of Article 6, which is criminal in nature or civil in nature, the president then assumes personal liability in the context of the decision of the High Court.
Sophia Kuka.
Cultural nights. Best of the both world. We are here for tonight.